Right, I finally got my microphone unpacked and it's ready to go here. I hope it's sounding okay. I did have a long move and I may have damaged it, so if the sound quality is poor, I might have to get another microphone. At any rate, time for another Binger Boneheaded moment. This is number 8. I've already covered this in a previous video, but I thought this deserved a boneheaded moment of its own. Thomas Clare Binger is going to get in a lot of trouble with the judge. Now, what he did here to get himself in trouble is not so much boneheaded as it is evil. But he got caught. The boneheaded part is how he reacted. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dread
You'd agree
Show.
with me that you were not allowed to use deadly force to protect that car source building, correct?
Well, I wasn't using deadly force to protect the property. I used deadly force to protect myself, so...
Glad that Kyle got that in. It's not what he was asking, and so he didn't really answer the question, but good for him.
Please listen to my question and answer my question if you can. You'd agree with me that you were not allowed to use deadly force to protect that car source building, correct?
Yes.
You'd agree with me that you were not allowed to use deadly force to stop someone from smashing the windows of an unoccupied parked car, correct?
I don't think you could use deadly force for that.
You'd agree with me that you can't use deadly force to stop someone from lighting a metal dumpster on fire, correct?
Correct.
You'd agree with me that you can't use deadly force to stop someone from tipping over.
Correct.
You'd agree.
Okay, I don't know what happened to the sound there. I think that's on the original video source, but he's leading up to the CVS store footage. He wants it in, and so he's asking a series of questions that he thinks is going to allow him to open that door, but no, it doesn't quite work out that way because Thomas Clare Binger violated a serious courtroom procedure here, but let's go on.
Can't use deadly force to stop someone from lighting a flatbed trailer on fire, correct?
Correct.
You'd agree with me that you can't use deadly force to stop someone who is about to start an unoccupied car on fire, correct?
Correct.
Again, all these questions. He has one question in mind. He's just trying to build up to it.
You'd agree with me that you can't use deadly force to stop someone from lighting some traffic cones in the middle of the street on fire, correct?
Correct.
So you understand that there's a difference between using deadly force to protect yourself and using it to protect property, correct?
Yes.
And you'd agree with me that you're not allowed to use deadly force to protect property, correct?
Yes.
But yet you have previously indicated
Uh-oh, you have previously indicated.
that you wished you had your AR-15 to protect someone's property, correct?
Both the defense and the judge, they got on this immediately. This is a blatant violation of courtroom protocol. And Binger knew it. Or he's stupid. Which one?
I'm going to ask you to go into the library again for a moment, please. Please don't talk about the case.
Now, a lot of the leftists out there, the anti-Kyles, still haven't figured this thing out. They're all on social media claiming how nasty the judge is and how he didn't allow Binger to present his case. And why doesn't he allow Binger to go ahead and talk about the CVS video footage? They don't know the law. They're clueless. They think the law is the way they want it to be. And that is, well, if you have evidence that shows that the person is a bad person, you should be able to present it. It doesn't work like that. We want people to be convicted on the evidence surrounding the event, not something in their past. There are exceptions, and these exceptions are why we have motion hearings. So the judge can look at your argument and decide for himself whether he thinks that these other acts, as they call them, should be admitted. And Binger already presented the CVS video footage as evidence that he wanted to present, and the judge said, basically, I'm leaning towards not letting it in, and that was the end of it. In other words, the judge did not allow it. If you want that other act's evidence to be included in the testimony, you have to get permission. The judge is just so steamed here. He's trying to gather himself in. It's lucky he doesn't have a gun, or there'd be another Kenosha shooting right now, and Binger would be the target.
Mr. Richards?
Your Honor, Mr. Binger is either forgetting court's rulings or attempting to provoke a mistrial in this matter.
Now look at Binger. He's not even looking at the judge. He's pretending to be looking at his notes. He's not looking for anything in there. What do you think he's looking for? Some sort of testament that he can go ahead and present this evidence in front of the jury? There's nothing in there. He's just keeping himself occupied. He doesn't want to look at the judge. This is called rude. And this is part of the boneheadedness. He should be looking at the judge with eyes that say, look, I feel like I'm in the right. But he knows he's in the wrong. He's doing what my dog does. When you find something broken and the dog looks away from you, that's called guilt.
He knows he can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an
Mr. Binger?
First of all, Your Honor, this was the subject of a motion.
You really need to look at the judge when you're talking to him, Binger. This is, again, really boneheaded on your part. You've been caught, you're guilty, and you're looking down at your notes because you don't want to look at the judge eye to eye.
well aware of that, and the court left the door open.
For me, not for you.
He walks away from the judge. He knows what's coming. He doesn't care, I have a feeling. He got what he wanted in front of the jury. He got them to hear it. But the whole point of having a motions hearing is to determine whether the jury should hear it. And the judge already said that he was leaning towards not letting them.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. I did. I granted.
We did not move
that
to
was
reconsider.
their motion.
Don't argue with him on this. This is a very small point. Just let him have it, Binger.
We've not filed any motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives...
Look at the chiropsy. He's like, yeah. He's enjoying this.
Well, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed another acts motion on this exact issue because, in my mind, and I argued this.
By the way, he said, I don't know what you're up to. He knows what he's up to. He's just trying to get that in front of the jury, and he's taking a gamble that the judge won't kill him if he does. And it worked. I mean, he did get it in front of the jury, but I have a feeling the jury's back there thinking to themselves, oh my gosh, that prosecutor is a real jackass. Now, not everybody on the jury is going to understand what happens, but some will. They'll say, yeah, I don't think he was supposed to bring that up.
It is identical to what was going on the night of August 25th, that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect...
I'm not going to rehash the motion. That's absolutely untrue. No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest that anything's changed, even if you're correct in your assumption that you know more than I did at the time. You should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
Your Honor, there have been things in this case.
Okay, Binger. Again, this is Binger boneheaded moment number 8. You're not going to talk yourself out of this at this point. There's nothing you're going to say where the judge is going to say, I never thought of it like that. Tell you what, let's bring the jury back in. So you go ahead and ask Kyle Rittenhouse that question. It's not going to happen. You're just going to anger him some more. You were wrong. Admit it. even if you felt that you should be able to ask that question, you have to get permission from the court first. And you didn't get it. I would be saying, Your Honor, I agree with you that I should not have asked that question. I apologize. It seemed at the moment that it was okay, but now that you've explained this to me, I'm sorry. Let's go ahead and proceed. Try to save yourself a little, but instead, you're going to try to die on this hill. Okay, let's see how this works out for you.
Testimony in this case that I believe opens the door to this. For example, the defense has introduced evidence that the defendant pointed a gun at a man wearing yellow pants because that person was on a car on the car source lot. Now, there's no justification that I can think of why the defendant would point that gun at someone.
Why are you going through all this? Look, it's really quite clear. You shouldn't have done it. You did. Apologize. Tell him that you're not sure why you did this. Tell him that it seemed okay at the time, but now that you've explained it to me, I fully agree. Get out of this. This is really dumb.
The defendant has just testified this morning that he agreed with that person in the yellow pants, that he pointed the gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he said, he's acknowledged that he told the person in the yellow pants, yeah, you're right. I did point a gun at you when you were sitting on a car.
He said, I did. That's what he
Exactly.
testified.
So he's agreeing. May I finish, please? I'd like to have a chance to make a record if I could, without being interrupted, if that's okay.
Oh, man. Okay, you want to take on the judge like that, you go on ahead. Interrupting the judge and telling him that you want to be able to complete statements? Pretty ballsy. Kind of stupid, too. That's why this is Binger Boneheaded Moment number 8.
He has mentioned that he's acknowledged that he's used this gun to protect property. He's also just acknowledged that he knows he can't do that. I am attempting to impeach him now with the prior August 10th incident, 15 days prior, involving the same gun, where he is threatening to use that gun to protect property. It goes...
He had the gun with him.
Your Honor, he is saying he wished he did so he could shoot people.
You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was unarmed...
I want you to tell me what the defense theory of the case is. May I
respond to what you just said, Your Honor? I'd like to respond to what you just...
Did you see that look on a judge's face? We got to go look at that again.
I want you to tell me what the defense theory of the case is.
May I respond to what you just said, Your Honor? I'd like to...
Oh, man, that judge wants to strangle Bing or something terrible.
Respond to what you just said. I apologize, Madam Court Reporter, but I'd like to try and make a record without anyone interrupting me, if that's okay.
The court reporter is struggling to keep up with all this.
I believe that there is a central part of this case that Mr. Rosenbaum is making threats that he has no ability to carry out. So, to your point, Your Honor, you're arguing that this August 10th incident, one aspect of why you don't believe it's relevant is the defendant didn't have the gun with him. This case is about someone who didn't have a weapon, and yet the jury is being told because of those threats, that means the defendant has to defend himself. So, with all due respect, Your Honor, mere verbal threats have already been shown to this jury and used as a basis for someone's subsequent actions.
Yeah, Binger, but Joseph Rosenbaum said him that night, moments before the actual shooting. You're trying to bring in other acts evidence that took place weeks prior. And another thing, you can't treat the accused like you can a witness or a decedent. The accused has certain rights available to them that witnesses or decedents don't. So just because Joseph Rosenbaum threatening to kill Kyle is somehow admissible doesn't mean that what Kyle Rittenhouse said 2 weeks prior is admissible. It doesn't work like that. No, like the moment I caught him in. That's about right.
I am attempting with the defendant to use his mere verbal threat on August 10th, 15 days prior, that he's going to shoot shoplifters with his AR-15 to impeach the defendant in a murder trial. I would ask the court's forbearance to do that. I apologize, Your Honor. You're right. I probably should have brought this to your attention earlier.
By the way, I apologize is not the same as I'm sorry. I apologize is when you really are not sorry and you're just wanting to get an apology out there. The look on the judge's face is like, golly, man, I gotta listen to this shit.
I may have misunderstood your ruling because I made that more relevant, you would admit it or at least consider it an admittance.
I may have misunderstood your ruling. The judge said it's propensity evidence, and I'm leaning towards not allowing it. There's not a whole lot of misunderstanding that can take place there.
Believe, based on the evidence that we've heard, and more specifically, exactly what the defendant said earlier about admitting pointing a gun at someone who was merely jumping or sitting on a car, that the door is open now to this testimony. And I continue to believe that his state of mind, his intent, his belief as to self-defense is the core of this case. That was the basis for my motion. You were strongly inclined against it. I understand that.
Well, obviously you didn't understand that.
But now we're in the middle of trial, and there's been a lot of evidence that's come in that I think makes this relevant. So I am attempting to impeach the defendant on his beliefs. I believe I'm entitled to impeach the defendant on his beliefs. And
then you file a motion. You're saying, I believe that this is now admissible. Then you file a motion for the judge to consider it. And if the judge decides that it is, then you can ask the question. You don't do what you did.
on his statements.
I'm going to interrupt you now because you're talking about his beliefs. I think that's what they call
his statements too, Your Honor. Because he just said, can't use deadly force, can't threaten to use deadly force to protect property. So now I'm impeaching him on that.
Your Honor, the court has seen no reason to change its ruling. And just so this record is clear, in spite of the lengthy statement by Mr. Binger, before we started today, the court specifically stated in Mr. Binger's presence, there's been nothing to have me change any of my rulings. There have been numerous occasions during this trial where they've opened the door. The one time when they're going into Mr. Rosenbaum's the reason he doesn't like guns. And I said something, I whispered in Mr. Krause's ear, it's because of the prior convictions. Please stop. And he did. He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
Yeah, it's ridiculous. Binger's been a lawyer long enough to know better. But then again, it's Binger.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings.
So why? Testimony, Your Honor.
Pardon me?
That was before the testimony.
Don't get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now. If it's not similar, that's the whole rule. Those are all the exceptions to 90404. Check the authorities. Wigmore and evidence. Judge Weinstein, Colonel McCormick. It's the prior act has to bear the signature of the accused, or it has to be so similar as to suggest it's a common plan or something like that. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions, whether premeditated murder or whether self-defense, that's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in, no matter what you think. Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line, close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.
Yeah, going out there and explaining yourself really worked well, Binger. Rather than bailing out early and asking for forgiveness, hanging in there and trying to explain your case really worked. Binger Boneheaded moment number 8. And keep in mind, I'm posting this because there's just so many people out there who don't understand propensity evidence. They don't understand other acts motions. They don't understand anything. They think they know, and there's a big difference between the two. Like my video and subscribe to my channel. And if you're a lawyer, don't do this.